Hello classmates, hello attorney, I am Derrica May, reporting for Group 3. Squibb Sons Corporation sued Green Valley for unpaid goods. The facts of the case. Squibb Sons Corporation and Green Valley entered into a contract which appoints the latter to become its non-exclusive distributor for Squibb Veterinary products. Goods were delivered to Green Valley and it fails to tender payment to Squibb, which prompted the latter to file a petition to claim the payment of the goods. The defense. Green Valley claimed that the contract with Squibb was a mere agency to sell, that it never purchased goods from Squibb, that the goods received were on consignment only, and the obligation to turn over the proceeds less its commission or to return the goods if not sold. And since it has sold the goods but not have able to collect from the purchasers thereof, the action of Squibb was premature. Squibb claimed that the contract was one of a sale, so that Green Valley was obliged to pay the goods received upon the expiration of the 60-day credit period. The issue of the case, whether or not the contract executed by Squibb and Green Valley is an agency to sell or a contract of sale. Ruling of the court. The contract was an agency to sell. According to the court, the contract need not to categorize whether it is an agency to sell or one of sales, but it uses the argument of the petitioner claiming that the contract was an agency to sell. In the case at bar, the petitioners sold the products on credit without the permission of the principal or the respondent. Therefore, Green Valley is still liable to pay for the proceeds of the sale it makes. In the contract of agency to sell, it provided in Article 1905 of the new Civil Code, it states that the commission agent cannot, without the express or implied consent of the principal, sell on credit. Should he do so, the principal may demand from him payment in cash, but the commission agent shall be entitled to any interest or benefit which may result from the sale. Now, what are the difference between an agency to sell and a contract to sell? A contract of sale. Rather, buyer pays for the price or the goods for the properties purchased in a contract of sale, while in a contract of agency to sell, the agent does not pay for the price. He just merely accounts the proceeds of the sale he makes. In a contract of sale, the buyer becomes the owner of the goods of property purchased, while in a contract of agency to sell, the agent does not become the owner of the goods of the property delivered for him for sale. In a contract of sale, buyer cannot return the products or property when the sale is defective, while in the contract of agency to sell, as mentioned by the petitioner, the agent returns the goods or property if he was not able to sell the same, while in the contract of sale, the seller warrants the goods or property sold, whereas in the contract of agency to sell, the agent does not make any warranty as long as he acted within the given authority and in the name of the principal. Now, the test whether it is a contract of sale or an agency to sell, we test the whole document according to the essential clauses. Now, in Article 1466 of the new Civil Code, it states that in construing a contract containing a provisions, characteristics of both contract of sale and the contract of agency to sell, the essential clauses of the whole instrument shall be considered. In the case at bar, Squibb and Green Valley entered into a contract which really shows that it establishes a contract of an agency to sell and not a contract of agent and not a contract of sale. Now that's all for our group, and thank you.